Texas District Attorney and County Attorney Candidate Forum, co-hosted by The Appeal and Now This. I'm Jay Willis, Senior Contributor at The Appeal, and your host for this afternoon. Travis County, Texas has a population of over 1.2 million people, making it the 5th largest county in Texas, and its largest city and county seat is Austin. Now, Travis County has a unique system that divides criminal cases between the district attorney and the county attorney. So the first one, the DA's office, prosecutes felonies, while the county attorney's office prosecutes misdemeanors and handles certain other civil matters. Now, a note to our viewers, it's going to be a little weird today because we have candidates for 2 separate offices related to the criminal legal system in the same forum. But since their work is so related and the occupants of both offices obviously have a ton of power to shape criminal justice policy in the Austin area, we figured it was worth it to have everyone on at once. So I'll try, and the candidates will try to, highlight some of these distinctions in their positions throughout, but that's just something to keep in mind. With that said, I'm excited to welcome our guests to this forum. There are 2 candidates in each race. Both elections will be held on July 14th. All 4 candidates in the races were invited to participate and are here this afternoon. On the DA side, with us today are Margaret Moore, the incumbent, and Jose Garza, who is challenging her. On the other side, the incumbent county attorney, David Escamilla, is retiring, and Delia Garza and Lori Iserloh are the 2 contenders to replace him. Some brief background about these candidates. As I mentioned earlier, Margaret Moore currently serves as DA and is running for a 2nd term after taking office in 2017. Jose Garza is a lawyer who currently serves as the executive director of the Workers' Defense Project, and he was previously a federal public defender. Delia Garza currently serves as Mayor Pro Tem of the Austin City Council, representing District 2 in Southeast Austin. She was previously a firefighter and Assistant Attorney General for the state of Texas. And lastly, Lori Iserloh works in the Civil Litigation Division of the Travis County Attorney's Office as a member of its employment team. Candidates, several crises in America are colliding right now. We're seeing the killings of George Floyd, Rayshard Brooks, and Breonna Taylor, among tragically many others. The violent police responses to peaceful protests of that violence in many cities, and the grave threat posed by COVID-19, particularly to vulnerable communities and people of color. These crises are exposing real inadequacies of America's legal system and also real differences of opinion on how to truly pursue justice and equity. So today, candidates will begin with a 90-second opening statement from each of you, starting with Delia, and then we'll move on to a question and answer period. When we get there, you'll each have 90 seconds to respond to a question, and I'll follow up if I need to. Please don't make me cut you off. I will if I have to, but then I'm going to feel bad about it, and the energy is going to be all off. So with that said, Delia, please take it away.
Good afternoon, and thank you for this opportunity. I'm Delia Garza, a former Austin firefighter. I left the department to go to law school. I'm the first in my family to be a lawyer. I was a non-traditional student. I went to law school later in life. I'm running for Travis County Attorney. As you mentioned, I am currently the Mayor Pro Tem, the first Latina on the Austin City Council and the first Latina Mayor Pro Tem in Austin. I'm running for County Attorney because Travis County is ready for massive change to its criminal justice system, especially in the County Attorney's Office. For decades, this office has pushed policies that have devastated our Black and Brown community, and now is the time for change. As you mentioned, people have been taking to the streets demanding a more fair, humane, and smaller justice system, and I have been proud to stand with them because it's time to dramatically shift course. We must end unfair policies like cash bail because study after study shows that money bail is not necessary to ensure appearance in court. We will also end the process of using prosecution, guilty pleas, and jail as a solution for all of society's problems. The criminal justice system cannot solve poverty, it cannot solve homelessness, and it cannot solve substance use disorder. We've tried using the threat of the criminal justice system, and it has been an utter failure. We need reform, and we need reform now. We will do our part to hold police accountable and in ending the disparities that result from policing. We will refuse to rely on the testimony of officers who have a history of serious misconduct. Changing the culture of the county attorney's office is going to take bold leadership and a willingness to stand up to people who want to maintain the old way of doing things. I have demonstrated throughout my career a willingness to stand up for what is right, even in the face of fierce resistance. It's that kind of fearless leadership that we need to achieve change, and it's that kind of leadership that I will provide. Thank you.
Unmuted, the first mute mistake of the day. Thank you, Delia. Lori.
Hello, my name is Laurie Agelo. I'm running for county attorney. I'm the daughter of a widow and a school teacher. I'm not a professional politician, but I'm running for change in this office. Let me tell you about myself. In 1992, I was a graduate of UT Law School, and I was the director of the Lesbian and Gay Rights Lobby of Texas. Now, that was a rough time. AIDS funding was inadequate, and people were dying from AIDS. That year, the Republican National Convention was in Houston, and the police attacked us on horses with tear gas, and they trampled us and they arrested us. I stood at that time and I was ready to fight for reform, and I'm happy to say the reforms that I fought for have come true, including marriage equality. But now again, we are marching in the streets, and again, those meant to protect and serve, they are trampling upon our rights. We're seeing the effect of 400 years of racism in our criminal justice system, a time when almost every problem is addressed with a criminal justice solution. Travis County, you have made some big changes over the years, but much more must be done. Long before we took to the streets, I was meeting with activists who were actually caught up in the criminal justice system, and I crafted a 13-point criminal justice reform plan that's been on my website since December. Look, I'm a frontline trial lawyer with 27 years experience and an activist with a track record of proven results. Travis County, I'm ready to start fighting for you on day one. The other thing I'd like to point out is I've been endorsed by the Black Austin Democrats, the president of the Austin NAACP, and Austin faith leaders, which African-American faith leaders, which let me tell you, as an out lesbian, that was a pretty tall order. Why? Because they know that I'm standing for specific reforms to our criminal justice system, and I'm ready to go out and do the work, and I've been doing the work. Thank you, Laurie Agelo, County Attorney.
Thank you, Lori. Margaret, go ahead.
Good afternoon. I am the sitting Travis County District Attorney. I'm reflecting today on the fact that 60 years ago, John F. Kennedy was elected president, and I was a 12-year-old, and I caught on fire watching him. And I remember that he said the classic saying, "Ask not what your country can do for you, but what for you can do for your country." And having a politician, firebrand, liberal dad, it was a natural for me to always be involved in politics. I got to the University of Texas in '66, just ahead of the anti-war movement, and a time in Austin's history when students began to actually vote here, and we registered voters. So I have been a part of the Travis County progressive evolution for literally decades. And during that time, and that call to public service, I did answer the call, and I was the juvenile public defender for this county. I was an assistant district attorney for this county under our first reform, criminal justice reform DA. I was then elected county attorney, served in that capacity, and started programs like diversion and alternatives to prosecution. And then I went on to a different track for a while, had 2 more kids, and served this county as county commissioner and a couple of unexpired terms. And then I ultimately ended up at the Attorney General's office doing civil litigation, recovering dollars stolen from Texas Medicaid by fraud. So I've had a varied career. I came back from retirement to run for district attorney in the interest of building an office that was in the progressive tradition here, bringing about changes. And I am very proud of the record of 3.5 years of service. We started a family violence unit and an adult sexual assault unit, and our emphasis on violent crimes. We diverted thousands of cases off the district court docket, the low-level drug cases and low-level theft cases, reducing felony convictions on those offenses by over 90%. We've decarcerated, bringing our incarcerations down every single year to a 22. Is that the time? I don't know the time, sorry.
That's okay. We are at time, and I do want to get into some of these, and I promise we will during the Q&A.
Yeah,
I just want to make
I
sure we
don't have it. Is there a
but,
timer somewhere that we can be watching or something?
I believe you'll have little boxes pop up, but if not, I will also try and keep a rough time, and I
Give
can
us
signal
some.
like this.
Yeah, that'd be great. Thanks.
Sure. Jose, lastly, go ahead.
Good afternoon, Jay, and good afternoon to everyone watching in their house right now in their living room. My name is Jose Garza, and I am running to be the district attorney in Travis County, because right here in Travis County, our criminal justice system is broken. In the most progressive county in the state, members of our community, and particularly people of color, are hurt or killed every single year at the hands of law enforcement. And in the last 4 years, not a single officer has been held accountable. Not one officer who has killed a member of our community has been charged with the crime. And not one officer who has engaged in misconduct of any kind has been convicted of a crime. But it doesn't have to be this way. We have the power to fix this. I started my career as a public defender on the Texas-Mexico border, where I worked both at the state and federal level. And in those jobs, I saw every single day the way our criminal legal system weighs most heavily on working class people and on people of color. But I also served in the Obama administration, and it has been the privilege of my career to lead Workers' Defense Project. And what I learned in those jobs is the power that regular people have, that everyone who is watching has, to change their community, and most certainly to fix our broken criminal justice system. I hope people will get involved in this race and join our movement to reimagine justice in Travis County.
Thank you, Jose. I'll start asking questions now, but I do want to correct myself, something I said earlier. I believe I said 90 seconds for answer. Since there are 4 of us, it's going to be 60 seconds per answer. So brevity is our friend, folks. First question. The protests that we're seeing across the country right now, as we've alluded to, are coming at a really unique moment, right? And cities and states and counties are slashing budgets for things like housing, education, and healthcare during this pandemic. But for the most part, police budgets remain untouched, and in some places are actually growing. That said, the Austin City Council voted unanimously to cut some of the police department's funding last month, and Austin City Manager Spencer Cook has announced plans to cut almost 100 positions from the city's police department. So Delia, I'll ask you first, as Mayor Pro Tem of the Austin City Council. You voted with your colleagues to defund the department. Where do you think those funds should be reallocated to?
Yes, even before this was the incredibly necessary time because of the moment we were at. Since my first budget, I have been working to reallocate funds to our public health department, because as a former Austin firefighter, I've seen when, and I've said this a million times, when we are sending fire trucks, $1 million fire trucks, to health calls that have become an emergency because we weren't proactive in investing in health and access to mental health. We've gone in the wrong direction. And so for me, this needs to go to our public health department. We are in more of a public health crisis than we are in a crisis. And so there's programs, programs, mental health programs that this department funds, after school programs, programs that really have more of a lasting impact in really addressing criminal justice issues. And so for me, that is where I will be looking to divert funds to, is to our public health department.
Thank you. Lori, I'll ask you the same question.
So thank you so much for that question. This has been a big concern of mine. In my view, the funds that if we had control over, keep in mind county attorney, these are police funds, city of Austin. But where I think those funds should be going to is to mental health diversion. And here's the reason why. In Travis County, the jail is the mental hospital of last resort. We don't have true mental health diversion here. Now, there's a history of that starting in the late 80s when basically the state shut down our mental hospitals. They were outdated, needed to happen. The state promised that the money would follow people in the community. It did not. So right now we have a mental health crisis in Travis County. I went to Harris County and I looked at their mental health diversion center, state of the art. We need to have something like that here in Travis County, and we need the funds to do it. So that's where I would prioritize funds. The other area, if it was up to me, would be we have got to spend more money on COVID prevention and care in the Latino and African American community. Thank you.
Thank you. Jose, broadening just a little bit, what is your position on shifting public safety budgets in some of the ways we've been talking about by moving resources away from what we might call traditional law enforcement and investing in alternative public safety programs instead?
Jay, for the last 400 years in this country, we have been sold this lie that what public safety is locking up as many working class people or people of color as we can. But what we know through our lived experience, what we know from the data and the evidence is that what public safety is a good job. It's access to healthcare. It's access to good schools to send your kids. It's access to mental health services and harm reduction policies. What public safety is stability. And so it is time for us to invest our money wisely in the things that we know will create stability in our neighborhoods and communities and that will keep us more safe. That means investing in harm reduction strategies to fight the scourge of substance use. It means investing more in our mental health systems. It means investing in programs that give young people the opportunity to reach their full potential.
Thank you. Margaret, lastly to you.
I think I'm going to say this. We deal with felonies, but we also deal with, I have the juvenile prosecutions here in the county. And I started out as a juvenile public defender, so I do believe in youth programs. And I'd started diversion back in the 80s in the county attorney's office, so I do believe in diversion. I'm hopeful now that we can see some money put into deflecting folks from even being arrested on low-level cases. I think there's promise in that. We've seen other programs around the country I'd like to see us invest in. I'm committed as the district attorney to supporting those. And I also think I have an important role in voicing concerns from our end that whatever defunding takes place, it does not harm the investigations that need to take place in violent crimes, particularly homicides, robberies, sexual assaults, and home invasion type crimes like burglary.
Thank you.
Thanks for the signal.
Yeah, I got you. Candidates, moving on a little bit, the debates about policing that we've been talking about have also examined the role of police unions and how they frequently prevent officer accountability and oftentimes foster secrecy around policing. And sort of the conventional wisdom about this is that it's part of the natural prosecutorial reliance on police officers in doing their jobs that deters prosecutors often from challenging the culture of these departments and holding officers accountable for their conduct. And we've seen in some places calls to disentangle this close relationship by having prosecutors reject financial contributions from police or from police unions. Starting with Jose, what's your position on accepting contributions like this? And more broadly, if elected, what will you do to ensure that police officers are held accountable?
I have never accepted a dime in contributions from police organizations, and I have pledged that I never will. I think there are significant steps that we need to take to ensure that our district attorney's office is independent from police organizations. it is time to create a public no-call list so that officers who engage in misconduct and racism and xenophobia are not allowed to corrupt our criminal legal system. That makes us less safe when people can't trust our system of justice. I believe that it is time to expand the kinds of cases that a special unit in the district attorney's office investigates so that there can be true independence between the DA's office and law enforcement. And it is time to prosecute all acts of misconduct, take them to the grand jury within 30 days, and be public when getting them to the grand jury is not possible. Explain that to the public so that they know why.
Thank you. Margaret, same question to you with respect to police union contributions.
I don't think police unions buy prosecutors. I know they don't buy me. They have contributed to my campaign. I think there are two different things going on here. One is there is a lot of protection for police officers' employment, and it does affect the ability of a police chief to get rid of a bad cop. There's also the side of the situation where we do prosecute police officers, and I disagree with my opponent that we've held no officer accountable. We've taken officers to jury trial. Some offenses we prosecute through the regular course of business, like a sexual assault is going to be handled by specialized sexual assault prosecutors. If it's something involving use of force, it's going to be handled by my civil rights unit, which is completely independent from the rest of the office. Holding police officers accountable also includes letters I've written saying I won't sponsor a certain police officer as a witness. We have a very robust system of giving defense counsel all information we ever get about a police officer or any other state's witness that might be useful to the defense. It's automatically uploaded. There's lots of aspects to this that we use.
Thanks, Margaret. I want to make sure I understand there. You know, when prosecutors are going to hold police officers accountable, that obviously means prosecuting them. Does accepting police contributions, in your view, not create a conflict of interest or a tension in that mission?
It hasn't for me. They did not support me when I ran. They have been unhappy with many of my actions. I view their support, as I do all the local support I've received, as a testament to the fairness and the efficiency with which I've done this job and the transparency. You know where my money's coming from. And I'd put my record right up there. No, I do not think that necessarily causes a conflict. I think
recognizing sort of the
Sure.
relevance of an appearance of impropriety or conflict of interest, right? Is not accepting police money in the future something that you'd consider committing to?
I would consider it. I absolutely would consider it. I worked in the 1973 legislative session where we passed campaign finance reform, and the idea there was disclosure so that you could see where the candidate's money came from and you could make a judgment about whether that's affected their actions or not. I don't have money from big national PACs that you don't know where that money came from, but I do know that the citizens of Travis County can look and see where my money's come from. And
So
to me, that was campaign finance reform as we fought for it back in the 70s and continue to fight for it.
But do I understand correctly that as of now, you're not committing to refusing those donations?
Well, I am discussing it with the citizens of Travis County as we go through this campaign. It just came up recently as a big issue, and I frankly, we're in the last days of this campaign, and I know what I've done to make the Austin Police Association unhappy with me, and yet they have supported me. I'm not going to. I point to that as evidence of my fairness, and because I know that's the way they view it. Holding police officers accountable is a very difficult thing because, for the most part, those are hard cases. I've been in the grand jury seeking the indictments. I've been in the courtroom when we've tried them. I know how these cases go forward. And if there's a prosecutor in the United States of America who'll tell you these are easy cases to bring and win, they're lying to you. They're tough. But we've done it. So
I appreciate it, Margaret. Thank you. Delia, I want to turn to you. Do you accept money from police or police unions? What's your position on this?
I have signed the pledge to not accept any money. That being said, in this campaign, that being said, I don't think they were going to endorse me anyway because of very public statements I have made about my desire for police reform and more accountability. In my 2 previous campaigns as a council member, I was the front runner, and it is very common for every organization to give very small checks, frankly, to council members. We're limited to $350. I did receive in both of my previous campaigns $350. After these pledges were I had already intended to donate that money to local nonprofits. After the pledge was made public, they sent a letter to me demanding that I give that money back to them. I made a public response that I would not give that money back to them because I did not want them to use that money to bully another elected official. So I donated to the Austin Justice Coalition, the exact amount. I donated an equivalent of $700 to the Austin Justice Coalition, to Texas Appleseed, and to Texas Fair Defense Project.
Thank you. Lori, same question. What's your position on this?
Well, Jay, back in April, the Austin Police Association did offer me money, as Ms. Garza just said. I'm the front runner in the race, so they did offer that to me. I rejected that money and did not accept it. Why? This was before the protest. I rejected it because of the Tatum report. Now, there was an allegation and investigation pertaining to use of racial epithets by an assistant chief of police. And I didn't feel comfortable. There was also an allegation of homophobia. I read the report carefully. I didn't think that was substantiated, but I did think there was circumstantial evidence that, to my view, substantiated racism at the highest levels. Now, here's my view on it. As a misdemeanor prosecutor, we have a very direct role in this, and it's hard for me to answer all these questions in 60 seconds. I will try.
I appreciate
it. So I was concerned and I rejected that money. Here's why. Because in Travis County, we misdemeanor prosecutors have 3 very specific things we need to do to stop police brutality and abuses by the police. We have got to indirect file. And I need an arm's length relationship with them in order to do that. We have got to push back when police file bias cases. Number 2, we have to review all the resisting arrest videos. And we've only got 180 days to report that police officer for discipline or and we have a little more time. Okay, I'm sorry, guys. I just can't answer it all so quickly.
That's okay. We're gonna have plenty of time to touch on the same subjects. I appreciate your consideration of that.
Yeah.
I want to move on to another subject that's been in the headlines recently. In the middle of the night on March 13th, we saw police in Louisville, Kentucky execute a no-knock warrant and enter the apartment of 26-year-old Breonna Taylor. They opened fire and they hit Breonna at least 8 times, killing her. Police ultimately found nothing illegal in her home, and in fact, the person they were searching for was already in custody at another location. And the tactics police used here are employed by departments all over the country with disastrous results, and they're dangerous for both civilians and the police officers who serve these warrants. In the wake of Taylor's death, the Louisville City Council unanimously passed a law banning no-knock warrants altogether. So Lori, I'll start with you. What's your position on creating a policy barring prosecutors from supporting law enforcement requests for warrants like these? Would you publicly support a ban on no-knock warrants?
Well, I would publicly support a ban on it, although as misdemeanor prosecutors, it's not necessarily something that comes up all that frequently. So I'm going to save that time for the candidates that are going to be dealing with it directly. But we are, as I've mentioned, dealing with the effects of 400 years of racism and those no-knock warrants. And what we saw, the result of that in Breonna Taylor's case, is very concerning to me.
I appreciate it. Thanks. And thanks again for bringing up the distinction between the 2 offices. And we're all doing our best to make sure that's clear. Delia, same question.
absolutely would support that with the caveat that this office would not deal with that more. But that all being said, it's important to understand as elected leaders, you have the privilege of the bully pulpit, and that allows you to advocate for, even though you may not have direct power over it or be involved so much, it gives you the power to very publicly talk about these issues and talk about why they are unacceptable and not necessary. And in addition to having relationships with advocates and the ability to literally walk, the county attorney can go walk to our Texas Capitol during legislative sessions and advocate at hearings for policies that prohibit things like this in our criminal justice system. And I would absolutely want to make this office more visible than it is right now. So many people don't even know who our county attorney is. We need somebody who's willing to be out there on all the issues, and issues like this included.
Thanks very much. So turning to the candidates who, as we said, will be dealing with this a little more directly in their execution of the duties. Jose, what do you think?
I'm opposed to the use of no-knock warrants. I think they make our community less safe, and I absolutely support a ban of their use.
Margaret, same question.
Same answer. I hate them, and totally would support a ban on them.
Fair enough. Staying on the subject of some of these more controversial stories we've seen with police recently, I want to turn to something we alluded to earlier, these Brady or no-call lists.
Mhm.
When prosecutors identify officers who are deemed too untrustworthy to testify in criminal matters based on prior misstatements or misconduct. So last November, I understand that some local advocates asked Margaret, in her position as Travis County DA, to implement a formal public no-call policy for officers who have, quote, committed perjury and other acts of grave misconduct. Margaret, what is the progress on that request, if any, and what is your position more broadly on this issue?
Well, Texas has the broadest discovery statute in the United States. It's called the Michael Morton Act, and it puts a very heavy burden on the state to disclose any information to the defense that might in some way be helpful to them. So we have in our office, because of the Michael Morton Act, because of Brady, and because of a state bar ethics opinion that's also quite broad, a very, very liberal disclosure file policy where we upload automatically to the defense. The county attorney's office uses it as well. We put this system together. Any information that can be helpful to the defense. And so there's a lot of information that's given to the defense that might or might not be useful to them. In the instances where there's some kind of misconduct like you described, we now have an MOU, a memorandum of understanding that was entered into between the city and my office that ensures that they will forward to us disciplinary information that they will give us under state law. Some things are kept confidential by law. They're called a G file. And we don't get that information, but we have an agreement that we get everything else. So what has happened in my administration is that I do send letters of non-sponsorship in instances with approvable misconduct, but I don't publish the list because frankly, there are issues around publishing that without giving some sort of due process to the officers. So we've hesitated to do that, but we do in practice tell a department if we're not going to sponsor a witness.
What would that due process look like? Obviously there's the contention is that publicly funded salaries of police officers who have been deemed so untrustworthy that they can't be trusted to testify in court is a problem and a matter of public importance. What would due process look like, and are you committed to making that list public?
I am not committed to making a list public until we've assured ourselves that we know that we can do it without having the county attorney have to defend us in litigation. there are nuances to this. Due process to an officer would be giving notice to them that we have a disclosure file, notice to them that we're not going to sponsor them anymore, notice to the department, giving them an opportunity to respond to that decision, and then reaching some sort of way to decide that. It's more complicated than just publishing a no-call list, is what I'm saying, and we've explored it deeply. And I believe I have no problem disclosing the fact that there are officers, there are two of them I sent a letter on that we put to trial, one of whom was charged with perjury, so it's not too hard to figure out that we would send a letter saying we're not going to sponsor them. But other aspects of meshing this broad disclosure that's required by the Morton Act and what would you publish in a so-called no-call list are very, in my opinion, very need to be sorted through very carefully.
So I want to make sure I understand. You've talked about the due process requirements that you would have to go through first.
Well, that arguably, this is an area that we've been wrestling with.
So what I want to make sure I understand is recognizing that, as you say, you've determined that there are steps you have to take first. Are you taking those steps, or have you decided that those steps make it too onerous and that it's therefore not something that you intend to publish?
At this point, we felt it's very intimidatingly onerous. We have differing legal opinions on it. So frankly, there are a few people that we have told that their department, it's not necessarily just the Austin Police Department, you understand, and it's not necessarily just police officers. We do this with any witness that, in our opinion, we cannot put on I call it a no sponsorship, because we can't sponsor their testimony because we ourselves know it to be untrustworthy. So
thanks for explaining this, Margaret. I want to make sure I give the other candidates a chance to weigh in.
Sure.
Jose, what's your opinion on this? Would you publish a no-call policy, or excuse me, a no-call list?
Absolutely. And what is equally important to the due process rights of defendants is the public trust of our community. And that is why it is incredibly important that the district attorney's office disclose officers who have engaged in misconduct that makes them not suitable to participate in our criminal justice system. It is a necessary step to restore trust in our criminal justice system. And I believe that there is a process that we can use and will use to make sure that there is due process for law enforcement as well. When we win, our office will not only collect evidence of misconduct from law enforcement, but also from the public and also from our own investigations. And any officer who has engaged in misconduct, including a history of racism or xenophobia, or a failure to operate their body camera consistent with policies regularly, and other kinds of misconduct, we will publish their names. We will offer, obviously, law enforcement the opportunity to rebut the presumption that they are not fit to participate in our criminal justice system. And unless they do, we will make those disclosures publicly.
Thank you. Dalia, you might have to help me out a little bit here. I'm pretty sure the same question is relevant to the work you would do prosecuting misdemeanors. Please correct me if I'm wrong, but what's your position on this?
I believe it is relevant, and that is why I think it was just about 2 to 3 weeks ago, the Austin City Council passed a slate of reforms to create that no-call list, to have our Office of Police Oversight create that no-call list. As a young law clerk at the Texas Civil Rights Project, we were working on a police case, and I remember learning about there's confidential and non-confidential files that the public has access to when it comes to a police officer's history of misconduct. One of those files, I believe it's the A, is public, and then there's another file that's not public. And so within the constraints of what can be public information, we absolutely have to have a list to ensure trust in our criminal justice system. And frankly, officers with a history of misconduct and bias and racism should not even be police officers anymore. And so, in this, as we are reimagining this entire system, we need to also think about the state code that provides protections under 143, and it provides these protections to police officers. And so I absolutely support a no-call list.
Thank you. Lori, lastly, what's your opinion on this?
Okay. Well, I do believe within the bounds of due process, we need to create a do not call list and make it public. If the one that the Austin City Council has created is of quality that we could use in our office, I'm willing to look at it. But regardless, my office will be creating such a list. Okay, that's one thing. In terms of police misconduct, we have got to indirect file by the police and push back where there's evidence of bias. And the other thing that my office is doing, and we need to do more of, is review all resisting arrest videos. And if there's evidence in those videos that the officer needs to be prosecuted or set up for discipline, we need to take steps. Under state law, we've got 180 days to do that. And also the police contract. Really, I know a lot of attention is being paid to state law, but in order to get a handle on some of these police issues, this is really the city of Austin. And this is really where the city needs to get a handle on its own police contract. So I merely point those out. Thank you. Hope I answered your question.
Thank you very much. Candidates, I want to ask about two of the different communities that frequently come into contact with police because, frankly, society has sort of deputized police to handle these issues, despite the fact that they are rarely qualified to handle them directly. So first are people struggling with mental illness. I beg pardon. First, we're going to talk about people experiencing homelessness and then folks dealing with mental illness. So in Travis County, the number of unhoused people has increased by 11% over the past year. And many of those unhoused people tend to be overrepresented in the criminal justice system because jurisdictions lack the resources and the expertise to appropriately address their needs. So I'll start with Lori this time. What specific steps will you take to ensure that a person's lack of stable housing or their poverty does not affect their interaction with the criminal legal system or subject it to disparate treatment in that way?
Really glad you asked. This is the question that in some ways first pushed me out the door to run for this office. I'm very active in a homeless ministry downtown. And here's our situation. So many of the homeless population are suffering with addiction or mental illness problems. And so I think we as misdemeanor prosecutors have a very special role to play there. And one thing we can do is push back on direct file of issues like criminal trespass. That would really help us with that. And to divert, before we push those people through the criminal justice system, divert them to what I would like to have as mental health diversion. I'd also like, we do have some good programs already for people suffering with substance abuse and addiction, but we need more of those. And look, let's face it, we can do all the wraparound services that you want, but if the person that we're trying to treat is really living under, a bridge, I mean, how much good are those doing them? We have got to get the state back to the table, and we have got to get some more supportive housing here in Austin, Texas. And that's my answer. Thank you.
Thank you, Lori. Delia, same question. What will you do to minimize the interactions between police, the criminal legal system, and people experiencing homelessness?
Sure. I first wanted to say in your previous question about where to allocate funding from the police department, I should have also mentioned in housing as well. It needs to be reallocated to public health and to housing. Second, not even what I would do, what I have done. We decriminalized homelessness in Austin, which became incredibly controversial, and we got harsh pushback and pressure to reinstate those policies. And we knew that it was the right thing to do, that we cannot prosecute people for the fact that they have nowhere to go. And so it is declining. Even, most crimes in the misdemeanor arena are crimes of poverty that largely affect our Black and Brown community. And so declining to charge those kinds of things like trespass and things that largely affect our homeless and our mental health We have a great start with the sobering center and diverting, instead of taking people to jail, taking to the sobering center. We need to ramp up and make those programs more robust.
Thank you, Delia. Jose, if you were elected, how could this position help reduce the interactions between people experiencing homelessness and people in mental health crises?
In Travis County, over 60% of people struggling with mental illness are also struggling with substance use. And we know that so much of our population of people who are experiencing homelessness in Travis County are struggling with both of those issues. And that is why I think it is time to end the prosecution of low-level drug offenses in Travis County. And when I say that, to be clear, what I mean is the possession or sale of a gram or less of drugs. It is time to end the prosecution of those offenses. One, because they don't make our community more safe. We know that the data is clear that every day a person struggling with substance use stays in jail, the likelihood they will commit another crime goes up. Continuing to use our resources this way makes our community less safe, and they are one of the greatest drivers of racial disparities in our system. And finally, it is time to end our cash bail system in Travis County. When people are sitting in jail simply because they can't afford to get out, it disrupts their lives. It prevents them from getting access to services and other things that can create stability.
You mentioned the cutoff at a gram. That's still a pretty low number. What makes you choose that threshold, and why not decline to prosecute cases that involve possessions of larger amounts that are still for personal consumption?
I'm so proud of the work that our city council has done to end the criminalization of homelessness. And I think that one of the lessons I took from that and from other work that we have been engaged in at Workers Defense and before is the fact that, we have used our criminal legal system for so long as a rug to cover up the problem of substance use, to cover up the problem of people experiencing homelessness. And what we have not done is invest in the infrastructure that is necessary to replace our criminal legal system. And so I think we have got to have time to build that infrastructure to make sure that we have other resources available to treat the root causes of these harms, and then we can begin to expand.
I understand. I want to make sure I understand, though, why the 1 gram threshold, which is, it's still a pretty low number. How did you arrive at that?
Well, as I said before, we know that it is one of the greatest drivers of racial disparities in our criminal justice system. We know that it is, I think, the fourth leading charge of women of color in our community. And so by starting at that level, we can make an enormous impact right off the bat as we build out the infrastructure that is necessary to address the root causes of harm.
What kind of timeline it sounds like what you're saying, and please correct me if I'm wrong, it sounds like what you're saying is that you would intend to start at 1 gram and then to continue to decriminalize possession. What kind of timeline and what kind of thresholds do you envision for that if you were elected?
I think what this moment has taught us is that we have to move as quickly as we can. We will initiate and institute our policy on day one and begin the process of and to be clear, our policy of not prosecuting a gram or less on day one, and begin to build out the infrastructure on day one. And if we can get that infrastructure built, within 30 days, within 6 months, that's when we should move. What should dictate our time is the pace with which we can build out the infrastructure, but we have to move with a sense of urgency.
What kind of limit what's the outer limits of this policy that you're talking about?
The lens that we should view all of this through is what makes our community more safe. And as we have an opportunity to implement these policies and review the data, continue to review the data, I think we can continue to make those assessments. I mean, my sense is, and when we look at communities across the country, we know that decriminalizing almost all possession has resulted in safer communities. And if the data continues to support that in Travis County, that's exactly what we're going to do.
Thank you. Margaret, same question.
So the question is about mental illness, right?
Yeah, diverting people who are experiencing substance abuse. Yeah.
Well, the the lack of resources in this community for drug treatment are noted by everyone who has any knowledge at all about what we need to be doing here. So building up the availability of those resources is very helpful. I also support the programs where people's going through a mental health crisis are dealt with by our we have a mobile crisis outreach team, and I believe the city's beefed up fund money for that, and so has the county. So I think that's a good thing. I know the sheriff doesn't like running the largest mental health facility in the county, and so we do have both the county attorney and the district attorney have mental health dockets, and the whole mission of those dockets is to find a way to get that person out of the criminal justice system. But when you get to a certain level of felony, whether that person is homeless or not, or mentally ill or not, then you're invoking whatever the remedies there are to deal with a violent crime or a high-level felony. When it comes to low-level drugs, I have a different approach than telling the community, okay, go ahead and use your heroin openly on the street corners. I just don't think that's what we want to do here. I think, though, what we do want to do is focus on the public's discerning the difference between a public safety need and a public health need, and using programs such as a street diversion or deflection program. The diversion programs that we do have in our courts and are very robust. I'm dismissing 60% of these low-level cases anyway for various reasons. So we are doing a little more nuanced approach.
Thank you. So I just want to make sure I understand the distinction. Do you currently prosecute cases for below 1 gram?
We prosecute some of them. Like I said, we're dismissing about 60% of them.
And what kind of factors go into your choices to prosecute or dismiss?
Well, there are a number of them. One of them is what was the public safety reason for making the arrest in the first place? What kind of problem is this person posing? Is this a person who only had a small amount because they're down there dealing at the homeless shelter, and they're smart enough not to have enough more than that in their possession? Was this in a neighborhood where the people in the neighborhood have been asking the police to help them clean up their the drug problems there that are affecting the quality of their lives? We look at different things like that. Is this one of the programs I've started is, hey, you want to take a community supervision or a diversion and go get treatment? We offer that regardless of your criminal history. But the nut of the problem is a lot of folks with very extensive criminal histories who continue to offend.
Thanks for that answer. I think this is the last thing that we'll have time to discuss. In February of this year, we saw Travis County judges issue an order stating that all persons arrested for misdemeanor crimes, which again is within the jurisdiction of the county attorney, should be released on personal bonds, so without cash bail. That order is subject to a series of exceptions, and some people have expressed skepticism over this policy, particularly the, quote, imminent danger to the community, end quote, standard of that, which they believe leaves too much discretion to the magistrates in this context. So Delia, since this falls within the jurisdiction of the office for which you're running, how would you respond to these concerns if you were elected?
Well, first, I think it's important that our criminal justice advocates be at the table when we're having these kinds of discussions. And my understanding is they weren't at the table, and it's important for us to have an order, and we're moving in the right direction. And I'm grateful for the direction that we're moving in, but we need to, Harris County, I feel, is really leading the charge in this area and being much more progressive. And any exception, there needs to be as little, every person arrested. We need a system that gets them out of the system as quickly as possible. And so creating any kind of exception gives me concern. And then there's other things in the system that need to change. There needs to be a prosecutor at magistration as well as a public defender at magistration. We don't have that right now. There's so many important checks and balances that we can implement that are not there right now. And it's a starting point, but we need criminal justice advocates at the table, an outside perspective at the table, re-examine pretrial services, their involvement in all of these cases, and get people out of the system as quickly as possible.
Thanks. Lori, same question. What's your position on this policy?
Well, I like the policy, but I do think that there's room for improvement in it. Real quickly, I mean, respectfully, Travis County actually had taken the lead starting in the late 70s on relying on PR bonds instead of cash bail. Harris County was sued and in federal court, and actually the system that Travis County is now looking at was taken from a consent decree in Harris County. I was supportive of Travis County basically not allowing pretrial services or making them take the time to check personal references before releasing people. I agree, people have got to get out of the system as quickly as they can and back to jobs and families. That being said, I agree with my opponent that everyone needs to be at the table when those decisions are being made, including advocates. The other thing I'd like to point out, though, is that we have not had as much time with the new order in effect as I'd like. I think it went into effect in February. And of course, we've been on a lockdown with all kinds of other things going on. But I do feel that the order needs to be, looked at and potentially broadened. I did visit Harris County and I looked at their system of magistration. We definitely need to have both prosecutor and a defense attorney at magistration. I think it's constitutionally required in Booth versus City of Galveston. And it's something that I would be very supportive of here. And in fact, have written a letter in support of getting some grant money on that. Okay.
Thanks very much. Candidates, I would love to ask a couple more questions, but I know we are at the top of the hour. So I want to thank you again for joining us today.
Just say one thing. We also have a felony order like that the county attorney and I both proposed. So the felonies are doing the same thing. Just saying.
If we can keep
Jay, if I may, then let's do
this. Let's do this. We can talk about this. If we keep it to 45 seconds, I want to be respectful of everybody's time. Margaret, can I ask you first about the pre-trial detention in the felony context?
Right. We did. The district judges also entered an order for low-level felonies with doing the automatic personal bond. It was the county attorney and I who proposed these orders. But I think you need to know that exception was one that the judges themselves insisted on because they were concerned that if pretrial services just made this determination when there was some issue about public safety, that it should be in front of a judge.
Thank you. Jose, what's your opinion on this? Is this order properly cabined or would you change it in some way?
Jay, what I think people who are listening across the country need to know is that the result of that order in Travis County is that the overwhelming majority of people sitting in our jail have not been convicted of a crime, that the overwhelming majority of people sitting in our jail are charged with felonies, and that the majority of people sitting in our jail are not accused of a violent crime. I think we need to move to a very simple standard, which is that unless a person poses a threat to our community, and what I mean is that they are either alleged to have committed an act of violence or alleged to have committed an act of violence near in time to the offense for which they are charged, then they should be released on a PR bond.
Thank you, and thanks for making sure we could get that in. Candidates, again, thank you for joining us this afternoon. Viewers, this does conclude our Travis County Prosecutor Forum, and remember that's for 2 separate offices, DA and County Attorney. Reminder, primary election day is Tuesday, July 14th. And if you are voting by mail, your ballot must be received, not postmarked, by 8 p.m. on election day. So be sure to drop it in the mailbox a few days early. Thank you again to the candidates for joining us and for everybody.